Court of Appeals Division 1 is now in session.
Please be seated. Morning, counsel. Let me call your case. This is case CV 15-800, Marcia McKee et al. Versus the State of Arizona et al. This is the time set for oral argument. Counsel, as you both well know, you have 20 minutes to present your case. Mr. Abney, you can set aside 5 minutes for rebuttal. You can keep track of that time on the podium in front of you. As you know, we have reviewed the case, we've discussed the case, we're very familiar with your briefs and the arguments, so please keep that in mind as you present your arguments this morning. The only other matter I'll mention is that these arguments will be uploaded to the court website, so they will be available for the public to view if they get on our website. With that, Mr. Abney, your argument.
May it please the Court. My name is David Abney. I'm here with Dana Roberts, representing Marcia McKee. If everything else in this case blows up, the one issue that really should survive and go forward at the trial court is the claim for intentional infliction of emotional distress based on the state's cover-up. That is a post-death event.
Let me ask you a couple of questions that weren't entirely clear from the briefs, okay? And I have one about that intentional infliction of emotional distress claim, but with respect to the status of your client's son. So he was a Prescott firefighter, and it doesn't say, it just, the briefs assume that he had elected workers' comp. I assume he didn't reject workers' comp.
Not that I'm aware of, Your Honor.
Okay. And then by virtue of at least the state's argument that he became a state employee under the statute, so he never actually specifically elected state's workers' comp. That was only by virtue of the IGA, right?
That would be the only route to have the state to the state's workers' compensation kicking in,
Right.
as opposed
Okay.
to the city's.
I just want to make sure I understood that. So the only election was as a city, a Prescott firefighter.
Yes,
right?
Your Honor.
Okay.
There's nothing in the record that he ever elected or decided that he would want to change his status as a member of the hotshot team, City of Prescott Fire Department, to be an employee of the state.
Right, okay. Now, secondly, it gets a little confusing to me with respect to the emotional distress claims, because there's the one claim, I know there's some debate about this in the briefs, but you argue there's certainly an intentional infliction of emotional distress claim regarding what you allege to be the reckless and negligent actions, the supervisors leaving their posts and so forth that resulted in the death of your client's son. And that seems to me clearly an intentional infliction of emotional distress claim. The other claim that you make about the state misrepresenting and basically the government misrepresenting what happened to avoid blame almost sounds in a negligent infliction of emotional distress. Are you, and I read the complaint and it's not entirely clear, is the only emotional distress claim an intentional infliction of emotional distress claim?
Yes, Your Honor, because the actions are so outrageous and beyond what we would say would be what a civilized society should tolerate,
So
that it
both-
would justify it.
But you referred to
For both, Your Honor.
you referred to a cover-up,
Yes, Your Honor.
which is different than the set of facts that Judge Houle just asked you about. Do you want to continue on that?
Well, paragraphs 314 and 317 of the complaint deal with the cover-up. We don't know a lot about it, but we have alleged that the state was engaged in some sort of systematic effort to hide the truth of what actually happened. That what its employees did, our basic theory is that what the state's employees did in managing this fire was grossly negligent, extremely negligent, and outrageously so. And the state then tried to cover that up with an investigation where it cherry-picked the investigator and hid essential facts and never disclosed them. In fact, at the end of the initial report, the conclusion was, well, bad things happen. But if you're going to do an investigation and you're going to be honest with, especially with the parents and the loved ones of the firefighters who died, you need to be forthcoming and not hide the truth. And we say that sort of thing would cause emotional distress to any grieving parent or loved one of these firefighters. In particular, it caused extreme emotional distress and depression and upset to Marcia McKee.
Okay. I mean, typically the requirement of an intentional infliction of emotional distress claim requires the plaintiff to be present at the time of the conduct. So
Yes, Your Honor.
if you would address that.
Well, I will. I started to smile when you said that, because how are you going to be present during the cover-up? At whatever meeting or meetings the employees, officers, directors, and agents of the state decided to get together and handle this in a particular manner that we characterize as a cover-up, nobody would have been there except them. And that's the nature of a cover-up, a conspiracy, whatever you want to call this kind of event. So she couldn't have been there. They also, I think their other counter argument to this is, well, this is just a general thing that's aimed at the public. And I suppose for public relations purposes, the state would not like it to be known just how incompetent the fire managers were, just how bad a job they did, and why several of them actually abandoned their post. I mean, if this had been in the Navy and I was prosecuting this as a court-martial, you'd have them for desertion, dereliction of duty, and you wouldn't line them up against the wall and shoot them, but you come awfully close as far as the harshest possible penalties. It was a terrible, terrible event that happened. And it's not aimed, the primary victims of this kind of cover-up are the loved ones who want to know what happened to my son, what happened to my husband, what happened in all of this that caused them to die in this kind of an event. And the state hid that. And we believe that given the circumstances, the outrageous nature of the cover-up, that the state is liable for intentional infliction of emotional distress under these unique facts. And I think this echoes of the Florida case where the nurse and the doctor tried to cover up the cause of the victim's death.
Let's come back closer to home. If you've read the Court of Appeals decision in Guerra, you know I understand your argument, but the Supreme Court opinion in Guerra seems to cast doubt on your ability to launch such a claim, doesn't it?
I don't think so. We're talking about the notification of the unwise and premature notification of death. This is a different kettle of fish. This is not people who are incompetently handling a notification and not being thorough enough in investigating to make sure, well, do we really know that this is the right person who died, and is this the right family to notify? This is a situation where we're alleging government officials got together, colluded, came up with a cover-up, and then instituted that cover-up to the damage of our client. So I don't think this fits the Guerra model.
Well, the facts are somewhat different, but doesn't the law that the Supreme Court announced in Guerra pose a problem for your claim?
No, I do not believe so. I believe that's a distinguishable situation on the facts.
Just because the facts are worse in this case?
Well, they're different, and they're different and worse. I mean, this is not simply someone, and the public officials, the police officers in Guerra, were trying to do a good job to the best of their ability. They simply bobbled the ball. Here we have officials who are not trying to do a good job to the best of their ability. They're trying to hide the truth and conduct a cover-up. And it's you get echoes of Nixon here. The problem wasn't the break-in.
But the
problem was covering it up.
The issue in Guerra was intentional infliction.
Yes, it was.
I mean, I know you're trying to cast that as more of a negligence case, and this is more of an intentional case. But the Supreme Court dealt with intentional infliction as a matter of law in that case.
Sure. And I hope that if you're talking about as a matter of law kind of thing, that as a matter of law, this needs to go back down to the trial court to develop the facts and see if there really was a cover-up, and if so, what was the intent behind the cover-up, what kind of damage Marcia McKee suffered as a result of the cover-up. There's a whole bunch of factual issues that have to deal with, but at this stage, this is a motion to dismiss, and our allegations need to be construed to the point that if we can possibly carry forward on this cause of action, it should go back and let us carry forward on the cause of action. There's a lot here to prove, a lot to find out, a lot that's never been uncovered or discovered. We never had any discovery in this case other than public records, what we were able to obtain. Everything was cut off by the motion to dismiss. I'm hoping, one of the thing about going forward on this kind of a claim, and in this case at all going forward, is that there are mechanisms to find out the truth, as far as we can find out the truth, about what the state did following all these events, to make things public or to hide things, to conduct an objective investigation or to conduct a subjective, biased investigation. There's a whole lot to learn about, and we'll never learn about it. This is the last of the wrongful death cases. The other one's settled. Some wandered into federal court, and some stayed in state court, and they all settled except for this one. This is the last chance that Marcia McKee has to find out about this cover-up, why it was instigated, its parameters, its limits, what exactly happened. This is it. There won't be a second chance. I've dried myself out. Just a second. If there's no further questions on that,
No.
okay. The statutory interpretation argument is a hard one. I'm asking the court to be exceptionally strict in its construction of ARS Section 11952F. But if you read that language in a grammatical sense, then there needs to be some sort of action by ordinance or otherwise by the city that either approves the duration of the agreement or extends the duration of the agreement, and there wasn't one.
All right, let's assume that's right. What's the consequence of a violation of the statute?
There is no IGA. If there is no IGA, then Grant McKee never became an employee of the state. The only argument that I could see, if I were in their boots, I would be saying lent employee, although it doesn't fit well because you need to have an employee that actually goes along with becoming the employee of somebody else. And I would think it would especially not work when you have a public official. He was a city firefighter. And just to say, well, we're going to lend you to the state and have a nice day, go do what the state wants you to, that certainly is not something you'd like to see happen to city officials, to city officers. So I think you need to look at that with extreme scrutiny. But if there is no IGA, he is not a state employee. If he's not a state employee, then we don't worry about any sort of waiver or immunity or anything else. We just deal with the right of his mother to go forward on a wrongful death action. There wouldn't be any impediment to that could be raised.
The original IGA is approved perpetual?
The language is it's sort of a perpetual thing. It's basically renewed automatically unless you stop it like a magazine subscription. It just goes on and on and on.
And why isn't that sufficient?
They did not specifically approve the duration of the agreement as a separate act. The state's counterargument is, well, okay, they approved in general the agreement itself, and if you look at the agreement toward the very end, it has this clause about duration. The difficulty with that is, the specific language of subpart F talks about you have to have this approval of the duration before the agreement may be filed or become effective. And they're saying, well, we approve the IGA, but you can't approve something that has not been gone through the process of approving the duration. You would be adopting by incorporation a document that has no validity. It specifically talks about becoming effective.
Okay, is there any provision, though? I understand the logical consequence of what you're arguing, of course. Is there any provision in the statute that says that the IGA is void without such a resolution?
No. The precise language is unless you have that approval, the agreement, contract, or extension, okay. Approval shall be necessary before any such agreement, contract, or extension may be filed or become effective. So if you don't have the approval, the IGA never becomes effective. It can't even be filed. You got to have that agreement first, then you have a valid IGA, and you can attach it to whatever you want at that point. But until you have that, it just never becomes effective.
Isn't the or between approving or extending the duration of the agreement typically a disjunctive term? In other words, they have to, by appropriate action, approve or extend. Isn't that the way we typically interpret the word or?
or is disjunctive in general. In this particular case, it can't be because without commas setting off that clause, the clause really reads approving the duration of the agreement or extending the duration of the agreement. You would need to have a comma after approving and a comma after duration of the agreement to make it work grammatically. Without those to make it work the way the state wants it to work. Without those commas, no. Approving is modifying duration of the agreement, and extending is modifying the duration of the agreement.
Now, subsection B of the statute talks about all the things that have to be in an IGA, and it talks about the agreement has to specify the duration, has to specify the purpose, the manner of financing or budgeting, the methods to be employed. All those things have to be in the agreement. If I read the statute the way you want me to read it, Mr. Abney, the legislature has placed prominence on approval of the duration, and it hasn't placed any express emphasis on an independent approval of the purpose of the IGA, how it's financed, how it's carried out. That doesn't seem to me to be really a fair contextual reading of all these requirements, why you would pick one and those others wouldn't require some type of express approval. Is the duration more important than the purpose of the IGA? Why wouldn't the agency be required to expressly approve the purpose?
You have to ask the legislature, and that's one reason why in case after case I come before the court and say plain meaning. That the court should follow the plain meaning, the plain words of the statute. I don't know of any way to analyze the government to figure out what the legislators wanted to do. Justice Robert Jackson of the Supreme Court, in one of the opinions he wrote, says, what people are asking us to do to delve into legislative history is to psychoanalyze the legislature. And he says,
I don't think you have to worry about us delving into legislative history.
You don't. You never get to legislative history if you can look at the plain words of the statute and say, this is what it means.
I would argue you never get to it anyway.
Well, then you and Justice Scalia are an excellent company, although occasionally he broke his own stricture on that. But you wind up in a swamp and you never get out of it, because even if you say, well, I'm trying to find out what the legislature thought, well, there's a whole bunch of legislators, some of whom voted against this, and many of whom probably never really read it or understood what they're voting on. To try to say, well, we've got some scraps here, or we can look at how the bill developed and say from that we can figure out what the words mean. It's just an exercise in psychoanalysis, and as Justice Jackson said, he for one was not fit to do it. May I reserve my remaining time?
Yes.
All right, thank you.
Mr. Parrish?
Excuse me. May it please the Court. My name is Mike Parrish, and I represent the state of Arizona and the Arizona State Forestry Division. I'm here with my co-counsel, Brock Heathcott, who's at the council table. Even though...
Hold on one second, because I just want to be clear. The way I read your brief is you agree that the intentional infliction of emotional distress claim is not barred by the workers' compensation statute, that it's a separate claim to the extent that that exclusive remedy provision might apply, right?
Correct.
Okay, just want to be clear. Go ahead.
Right. Even though Mr. Abney devoted probably more of his time on the intentional infliction of emotional distress claim, I think I'd just like to start with the workers' comp issue, the IGA issue, which he characterized in his brief as the most important issue in the case. And Justice Gould, I'd like to start. I think it's Justice now. I'd like to start with one point.
No, let's not start down that.
You're only going to get me in trouble
Okay.
with these
Okay.
guys.
I apologize.
Please don't do that.
He's already wanting us to bow.
Okay.
That's hasn't happened.
As I understand the workers' comp statute 23-1022, there did not need to be any separate election by the decedent. The way the statute is set up in the IGA in this context, where there's a shared employee.
No, and I wasn't trying to imply that. I just wanted to understand whether, because the briefs start out with the agreement that if he was a state employee, the exclusive remedy barred it. And I just trying to understand in my own mind the path to how he got to be a state employee. I assumed it's what we discussed earlier with Mr. Abney. I just want to make sure.
Yes, and so, in a word, so long as as there is an IGA in place, he is an employee of the state for workers' comp purposes, and the workers' compensation that benefits would be provided by the city, not by the state. That's the way that 23-1022D is set up, which we cited page 16 of our answering brief. Now, with respect to the argument as to whether the IGA is effective, their argument is that the city council was required to do two things. It was required to approve the IGA, and even though the IGA itself set forth the duration of the statute, the duration of the agreement, as required by the statute, the argument is that the city council also had to separately approve the duration of the agreement in order for the IGA to be effective. That's wrong for two fundamental reasons. The first reason is plaintiff's premise is completely wrong. Their premise is that subsection F of the statute, and I'm referring to the subsection F that David refers to in his brief. The numbering or the lettering changes a little bit over the years. But the provision, their assumption is that F contains an approval requirement that relates only to approving the duration of the IGA, and that a separate subsection of the statute, subsection A, requires approval of the IGA itself. Based on that premise, that these are two separate subsections that set forth two separate approval requirements, they conclude that two separate approvals are required. But the premise is wrong. First of all, subsection A does not require approval of the IGA itself at all. The language that requires approval of the IGA is in subsection F. It provides appropriate action by ordinance, resolution, or otherwise, approving or extending the duration of the agreement or contract shall be necessary before any such agreement, contract, or extension may be filed or become effective. As we've explained in our answering brief, the correct interpretation of that is as follows. One, the council must, under subsection A, must approve the IGA to be effective. Secondly, if the IGA's duration is ever to be extended, the city council must then approve the extension of the duration in order for the extension to be effective. But our construction that subsection F deals with two separate approvals, one approving the agreement and then dealing with extensions only if an extension becomes necessary, doesn't depend on the existence of any commas, as Mr. Abney has argued. He cited no grammatical rule, no case, no legislative rule that would say that the absence of two commas completely turn upside down the meaning of that subsection.
But the commas would stress the disjunctive reading of it.
Oh, sure. The commas would stress it. That's definitely correct, Your Honor. Now, we feel very good about our argument as it was stated, as I've already summarized it, but I hope the court has had a chance to read the legislative history that we submitted in one of our supplemental citations. Because I think it's our first supplemental citation that we submitted a week or two ago, that says before the 1979 amendment of this statute, Subsection F required approval of the IGA, period. There was no mention whatsoever of the duration of the IGA. In 1979, it was amended to require that the City Council also approve any extension of the duration. So I think that eliminates any doubt as to what the meaning of subsection F is. It is, one, the City Council simply needs to approve the IGA itself in order for the IGA to be effective.
You know, I read that, but I didn't know what, I guess I saw it as cutting both ways. I mean, it could be viewed as the additional language was an intention to expand the scope of subsection F. So I couldn't read it either.
No, pardon me, Your Honor. I think it does. I think for the first time it deals with the duration of the agreement, and it deals with in the context of when there is going to be an extension of the duration. But the point is that the language before the amendment and the language before the amendment dealt only with approval of the agreement itself. And then when it was expanded in 1979, it was expanded to deal with extensions of the duration, not to eliminate the requirement of approval of the IGA and substitute it with some approval of the duration itself in order for the IGA to be effective in the first instance. But that's the first fundamental reason why the argument necessarily fails. But the second reason is even if the statute did require that the City Council approve the IGA and approve the duration of the IGA in the first instance in order for it to be effective, Judge Gould, as you noted, subsection A specifies certain terms that must be in the agreement, and one of the terms is the duration. What the City Council did here, it approved the IGA. In doing so, it approved it in its entirety. It approved every term of the IGA, just as though the resolution had recited every term in the IGA, including the duration. So I strongly disagree with the construction argument, but even if the construction argument were correct, to say that what the city did here is the IGA is not effective because it approved the IGA, which necessarily includes approval of every term, somehow isn't an effective approval of the IGA's duration, is with all due respect, is senseless.
So would you argue subsection D, which requires that these agreements be submitted to the attorney for the agency, it's the attorney who looks to see if all these requirements of B are in the agreement, and that's, I mean, why else, I guess, would you have that requirement that it be submitted to the attorney other than making sure the IGA was legal, it complied with the requirements under B? And then F is simply, once it's been submitted to the attorney, they approve it, it's an up or down vote on approving the agreement. Is that a fair construction?
That is correct, Your Honor. The only thing I was going to add, and this is the reason I hesitated, the resolution itself also for the city of Prescott also contains an approved as to form signature of the city attorney. And so the point is that the city attorney, in approving the resolution, recognized and agreed with the state's position that no separate approval of the duration separate from an approval of the IGA is necessary in order for the IGA to be effective. So in this case, we have an approval as to form not only as to the IGA itself, but as to the City Council's resolution that approved the IGA, including all of its terms. One last point on the IGA, and I don't know that Mr. Abney is squarely making this argument, but kind of came up in passing a little bit, is whether there's, I don't think he's making this argument, but to the extent he is arguing that an alternative argument that the IGA was subsequently extended after it was initially approved, and that somehow that extension ineffective because it was not, the extension later was not approved by the IGA. That would also be wrong, and I don't know that he's even making that argument. But the point is, I think, as Judge Swan noted, really the duration of this agreement is an unlimited duration. I mean, it's subject to the right of termination on 30 days' notice, but it is an unlimited duration. So as a result, no extension of the duration is necessary. The agreement remains in effect. And because the duration was not extended, there was no need for the City Council to subsequently approve any extension of the duration. There was never an extension of the duration.
So what about Mr. Abney's argument on the intentional infliction of emotional distress and this idea where you have to be present to make such a claim, and with this type of claim, it's emotional distress suffered from a cover-up. That's what's alleged. How could anybody ever be present at the time of a cover-up?
Okay, and Your Honor, to focus on that particular claim, I'd first like to address the most fundamental deficiency with the claim. Is there is nothing in the complaint for the court to conclude that this alleged cover-up constituted the extreme and outrageous conduct that we all know is required for an intentional infliction of emotional distress claim.
Well, you're saying as a matter of law, a cover-up cannot rise to the level of intentional infliction?
What I'm saying, Judge Swan, is in the complaint, specifically the paragraphs of the complaint that Mr. Abney referred the court to this morning, there is nothing in those paragraphs other than pure conclusions. There is not a single well-pled fact that would enable this court to conclude that the state engaged in any extreme and outrageous conduct post-fire that would give rise to an intentional infliction of emotional distress claim.
When you say conclusions, they're not legal conclusions. They are facts. They may be unsubstantiated. You may disagree with the allegations, but aren't we required to treat them as true?
I think they are nothing but conclusory without a single well-pled fact. And as I understand the law, to evaluate a Rule 12b-6 motion, the court considers well-pled facts and reasonable inferences from those well-pled facts. And just one, if you look at paragraphs 314 to 317, there are not well-pled facts that would enable this court to conclude that the state engaged in extreme and outrageous conduct in this alleged cover-up. That is the first fundamental flaw in the intentional infliction of emotional distress claim based on the cover-up. And because of that, the court need not go any further. But with respect to your question, Judge Gould, as to whether the significance that Mrs. McKee was not present for, or there's no allegation that she was present for these misrepresentations. And before I leave, the last point, if I could also add, Mr. Abney made a point, we didn't have a chance to do any discovery, and he referred to some other report that was done. The existence of this other report is not in the complaint, but it is true that they certainly could have, if they thought that there were facts in that complaint that would support a claim that the state engaged in extreme and outrageous conduct, the complaint was the place to allege some well-pled facts. Now, with respect to the fact that she was not present, a couple of things. First of all, it is true, the law is clear, and we submitted a long list of cases supplementally that under Restatement Section 46, Paren 2, that when extreme and outrageous conduct is not directed specifically at the plaintiff has to be present, has to be physically present. There's no allegation that she was. And I think that so here's what that means. If there's a misrepresentation made directly to the plaintiff, in her presence, she was present for it. But the allegation here
Well,
is...
what if she's part of a class of people? I mean, to come up with a hypothetical, if you have an individual who releases personal medical records of every patient of a hospital and makes them very public, and does so maliciously, are you saying that that could not, as a matter of law, constitute intentional infliction?
I am saying that, Judge. There are limits on an infliction of emotional distress claim. We cited a Minnesota case that recognizes that where conduct is directed at society at large, and that's what they allege this...
It's not directed at society at large, though. What if it's directed at a identifiable group of people?
Well, that may be, but because my time is limited, Judge Snow, the point is that's not the allegation here. The allegation here is that the state engaged in this amorphous cover-up to avoid any blame by anyone in society. That's the allegation. It's not directed to a class of persons. It's not directed to a survivors of the firefighters. It's not directed to homeowners. It's directed to society at large. And in that situation, the conduct is not directed at her, and as a result, she does need to be physically present.
Let's accept for a moment the idea that the facts are not sufficiently well pled to develop that theory. Should dismissal have been with or without prejudice?
Well, there was never a request for a dismissal without prejudice.
There doesn't have to be.
And there's never been any argument here that the plaintiff should have been given leave to amend, or that the court erred in making the dismissal with prejudice as opposed to without prejudice.
I just kind of go down the hypothetical path, and I know that that's not the case here. What if this had occurred at Grant McKee's funeral, and someone from the state had come up to her and directly misrepresented what had happened? Possibly. I'm trying to understand better if there's a set of facts that you would concede where misrepresenting what happened could be directed at a person and could cause them emotional distress.
Yes, I mean, Your Honor, I would not say that there could not be a circumstance where, if there were well-pled facts of conduct that is extreme and outrageous, and keep in mind, Judge, Your Honors, that the extreme and outrageous standard is a very high standard. We're talking about something that society considers utterly atrocious. Is that criminal conduct doesn't even necessarily qualify as extreme and outrageous conduct under the Ford versus Revlon case from the Supreme Court, or the restatement Section 46, which Arizona courts follow with respect to this type of claim. Very briefly, I don't know that it's even still on the table, but to the extent there is an argument that the handling of the fire gives rise to a claim of intentional infliction of emotional distress, that fails for a couple of reasons. One, the conduct is not extreme and outrageous, but more specifically, she clearly was not physically present for that conduct, and it was not conduct directed at her. And that's the key. It was not conduct directed at her. It was conduct directed, if anyone, at the firefighters, I guess, but certainly was not conduct directed at her. So that claim that necessarily fails. I have 15 seconds. I'll be happy to answer any other questions.
Thank you,
Thank you
counsel.
very much.
Mr. Abney?
The key word with intentional infliction of emotional distress is outrageous. I think the restatement second specifically says this is conduct that would lead somebody to say outrageous. I think they even put an exclamation point next to it. So if the state did what we say it did, it was outrageous. In paragraph 314, we talk about the fact that the state was engaging in misrepresentations to cover up the cause of the death of Grant McKee and the other members of the hotshot crew. Then we personalize it more in paragraph 315. We talk about the misrepresentations and cover up violating the public trust and multiplying Marcia McKee's emotional devastation.
But the representations are not directed at your client. What do you do with the physical presence requirement?
There's sometimes you just have to say this is just absurd to say that you have to be present if somebody's cooking up a cover up. She was present to receive the information that the state was giving out, but to actually to have to be there while they were
I don't
doing
mean
this.
to be insensitive, but now you're talking about a claim for intentional infliction that is not wrongful death. It's not limited to a class of statutory beneficiaries. There are a lot of people who suffered emotional distress as a consequence of the events we're talking about.
Yes, and that's why.
And are you suggesting that every single one of them has a cause of action?
No. Marcia lost her son and then had the state lie to her and the other survivors about what happened. It's very personal, and the complaint tried to specify that it was very personal to her, that it caused her emotional devastation, that it caused her to suffer emotional distress and depression because of
No
it.
doubt of that. I'm just trying to ask the legal parameters here. And if we have a restriction in the law that requires physical presence when the conduct isn't specifically targeted at a person, do we need to look at it from the shoes of the tortfeasor or the shoes of the alleged victim?
In this case, the shoes of the alleged victim.
So my question before about the potentially unlimited class of plaintiffs comes back. If we're going to look at it from the standpoint of the alleged victim, there can be a lot of alleged victims. A lot of people suffered.
Well, in a public policy sense, it would be unwise to extend this to the entire public. But we're not talking about the entire public. We're talking about the very narrow group of people whose loved ones died.
What about friends of the decedent? Close friends?
I don't know if intentional infliction of emotional distress would fit very well there, but perhaps there would be a claim. I can only say that's not the facts of this case. We have a very small group. In fact, now we have one person making this allegation that she suffered as a result of the state's conduct in engaging outrageous activities. So it's just the one person who has an incredible interest in what happened because it's her son that they're making misrepresentations about and saying, well, it's just one of those things, and it's not. He died because the state was negligent. And then after that happened, the state chose to lie about it. And she should not have to go through that. The stress that caused her to suffer is something that I am incapable of expressing adequately in words.
Is your client here today? Well, sometimes the legal system can seem very impersonal. Regardless of what we decide in this case, there isn't a member of this panel that doesn't feel great sympathy over your loss, Ms. McKee. So I certainly would tell you that.
Thank you, Your Honor. And congratulations on your elevation.
Oh, really? Don't go there with him. He's just made
I know, I'm
life
just
miserable.
I'm throwing fuel on the fire.
Like you did that to poke me in the eye.
Yep, I'm sorry, Your
All
Honor.
right, that's okay. You can sit down now.
Thank you very much. I didn't mean to be unduly facetious or anything like that. This is a very important case to me and a hugely important case to our client.
You understand?
Thanks all of you.
All right, thank you, counsel, for your arguments. We'll issue a written decision in due course. We now stand in recess.